Hey, you know that set of rules saying what the feds and states can and can't do? That dusty document called the U.S. Constitution that has an amendment process in it in case people want to change said so-called rules? Well, among many, the California government has shown complete disdain for those so-called rules and has gotten worse with time as its COVID crackdowns have destroyed even more rights. But don't ask a three-judge panel of the Ninth Circuit Court of Appeals about this, because they just ruled that the state indefinitely delaying criminal trials is not a breach of the Constitution. Hi everyone, I'm Gardner Goldsmith for MRCTV. Yes, the laughter hides the pain. Oh man, this is crazy. Hey, before we get into this new example of in-your-face judicial malpractice from what has historically been the most left-wing federal appeals court in the nation, let's take a look at the Sixth Amendment of the U.S. Constitution. Quote, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process of obtaining witnesses in his favor, and to have the assistance of counsel for his defense." Maybe they just don't know the number 6. You know, maybe they never learned that in Sesame Street. And let's look at this pertinent clause from the 14th Amendment. Quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." Come on, I'm on the Ninth Circuit. You can't bother me with this stuff. I got things to do. They're the Oscars. They're gonna move homeless people. You know, it's just so much more fun to be around California and not think about the Constitution or people's rights. It's cool. Now, here's the story, and pay close attention to how the LA Times covered it. Writing for the publication, Maura Dolan tells us, quote, "In a partial rebuke of a lower court jurist, a federal appeals court decided Friday that criminal defendants were not robbed of their right to speedy trials or forced unconstitutionally to remain behind bars because the COVID-19 pandemic delayed their trials." But that's not exactly what the court ruled. Let's continue with Ms. Dolan's stellar reporting. Quote, "Surely a global pandemic that has claimed more than 500,000 lives in this country and nearly 60,000 in California alone falls within such unique circumstances to permit a court to temporarily suspend jury trials in the interest of public health," end quote, said a three-judge panel of the U.S. Ninth Circuit Court of Appeals. So the Ninth Circuit panel didn't say that defendants, quote, "were not robbed of their right to speedy trials," end quote, because the panel did, in fact, acknowledge that jury trials had been suspended. The judges simply excused the clear violation of both amendments that we've mentioned, claiming that, well, these were special circumstances, so heck, what kind of stick in the mud would argue against letting the state do whatever the heck it wants? See? Yeah. Curiously, in her next paragraph, Ms. Dolan acknowledges that the trials were delayed, i.e. the plaintiffs had not received speedy trials before juries of their peers as mandated by the Constitution. But yeah, it's all cool. Quote, "The appeals court ruling effectively affirms that COVID-19 was an emergency that forced some courts to take unprecedented steps, including delaying proceedings. It means criminal defendants are unlikely to prevail in arguing that pandemic-induced delays should allow them to be released from jail or have their charges dismissed," end quote. In other words, a delay isn't really a delay because it's done for special reasons. And those trapped behind bars for months aren't really trapped behind bars for months. And evidently, the 6th and 14th Amendments come with asterisks reading "some conditions apply," which ought to make these federal judges pause for a moment. If the Constitution can be suspended whenever they deem it a special time, how secure are their vaunted tax-funded court seats? That appeals court is a creation of the federal government, which in turn is a creation of the Constitution and its written rules that are very plain to read. So if those rules can be disregarded any time some cabal in America wishes to disregard them, how secure does that make the Ninth Circuit judges' jobs? As Dolan mentions, one of the 3 cases which comprised this Ninth Circuit blanket ruling dealt with a Newport Beach doctor who had been prosecuted by the government for dealing narcotic prescription opioids. Quote, "In one of 3 cases, the panel decided it reinstated charges against Jeffrey Olson, a Newport Beach doctor who was indicted in July 2017 on 34 counts involving illegal distribution of opioids. Olson had successfully sought several delays in his trial while on bail. But after the U.S. District Court for the Central District of California, which includes Los Angeles and 6 neighboring counties, suspended jury trials due to public safety concerns over COVID-19, Olson invoked his right to a speedy trial. A district court judge heard his case and heard the state's argument about special circumstances, leading to U.S. District Judge Cormac J. Carney ruled in favor of Olson and dismissed the charges in a way that would make it impossible for prosecutors to refile them. The prosecution appealed. Which brings us to the unsigned decision from the Ninth Circuit judges Mary H. Margula, Morgan Christian, an Obama appointee and an Obama appointee, and Judge Barbara M.G. Lynn, a Clinton appointee who is Chief District Judge in Texas and sat in on this case. According to Dolan, quote, "Olson had asked for trial delays 8 times over 3 years and was granted them," the Ninth Circuit said. He demanded a speedy trial only after jury trials were suspended, the appeals court said, which makes no difference as to whether or not it was constitutional for the most recent court date as scheduled to be delayed. If the defendant and his attorney were ready and the state chose to delay, that is not the fault of the defendant or his counsel. That's the fault of the state, and previous overtures and requests by the plaintiff prior to the final court date that was delayed, suspended, in fact, are not pertinent to the constitutional issue of the state failing to fulfill its constitutional duty. The Ninth Circuit panel reveals their blindness to the clear constitutional breach by California once more in this statement, saying that Judge Carney, quote, "entirely failed to consider the facts and circumstances of Olson's case, including the years of continuances Olson obtained while on pretrial release in the absence of any prosecutorial culpability in causing the delay." But the facts and circumstances of Olson's criminal case are not what are at issue. What is at issue, regardless of the details of each claimed criminal offense, is that the state of California suspended its jury trials indefinitely, citing an excuse of a pandemic. It wouldn't matter if the so-called pandemic were a real pandemic or it was an outbreak labeled pandemic under the World Health Organization's redefinition of it in 2009, when they lowered the lethality threshold for an outbreak to be called a pandemic. The fact is that a state is forbidden from instituting such lengthy delays, or temporary suspensions, as they call them, regardless of the threat. And anyone who is accused of a crime is supposed to get a speedy trial in front of a jury. Now, critics of the Constitution, especially those who recognize that the previous governing document of the United States, the Articles of Confederation, was much more oriented towards decentralization and liberty, easily can note that, quote, speedy, end quote, is never clearly defined. But surely, given decades of California court operation that gets defendants to court within weeks, a year of canceled court appointments can't be considered speedy. Heck, even in left-wing Massachusetts, the state government has tried to get cases to trial, going so far as to rent the legendary Lombardo's function hall to allow for makeshift courtrooms that can offer all their pie-in-the-sky COVID spacing and camera communications.
State rented out the popular function hall and converted 2 ballrooms into courtrooms because of the pandemic.
We don't have a courtroom capable or able to hold a trial in Norfolk County because of the age and the condition of our courthouses. The courtrooms are too small. They weren't set up for this. And with the air quality issues, we're dead in the water.
Can't another leftist enclave like Gavin Newsom's California figure this kind of thing out? This ruling is frustrating, but it's an interesting and important issue to watch. On appeal, it could go to the United States Supreme Court and will help us see once more those justices who truly believe in the Constitution as the so-called set of rules, and those who couldn't care less. Hey, thanks so much for watching, everybody, and thanks for being interested in these sorts of stories. I think they're very interesting and very important, and feel free to comment if you're watching on YouTube. I read all the comments. I don't get to comment on all of the comments, but I do read them all. And find us over at Rumble as well. All the videos are hosted there. You can find us on TikTok, on Instagram, on Twitter, on Facebook, and on Parler. And if you get the opportunity, yes, indeed, the new website for the MRC shop. It's shop.mrc.org. That's shop.mrc.org. You can check out all the really good items for sale from the Media Research Center. And again, please go to MRCTV.org to find out what the whole team is doing. That's MRCTV.org. Check it out. For MRC TV, I'm Gardner Goldsmith.